Okay, so Mr. McKenzie, I understand that you just sent an email to the court.
Yeah, but domain of the address that she gave us, the domain name couldn't be found.
What's the email address, sir?
Email that she gave or my
The email that you are sending it to.
email I'm sending it to is ANILSEN@wine.gov.
You forgot the MI, wine.mi.gov.
I didn't say that.
Okay, well then go to the window, sir, to make sure that you have the correct thing. What is it you're trying to email to the court?
I'm emailing the videos. I'm emailing everything that shows.
No, that is not how that works, sir. We do not play the videos here. I don't know if there's any encryption or if there's going to be a virus that gets into our items. You need to be able to do that on your own.
I don't know what you mean. Bring all this.
Yes, that means bring it ready to go, not sending it to the court's email. So the court would then have to hit a link to play a video. That's not how we do it.
Well, I don't know how to do this. I thought that's what I'll send you the videos, or I can't show it to you on my phone. Well, what do I do? I don't know.
Then you screen share. You log in and you screen share. The court does not. Let me just be very clear. The court does not play any videos that are sent to the court because we have no. Please listen. Please listen. We have no way to know whether or not that's going to infect our hardware, our software, any of that stuff with the virus. So we don't do it that way. And sir, with all due respect, this matter was scheduled at 9 a.m. If you had questions about how that gets done, you should have contacted into the court prior to this morning.
I didn't think I needed to. I thought I just sent you the videos.
No, that's not how that goes.
Well, I didn't know that.
Did you show counsel the videos that you want the court to watch?
Him?
Yes.
No.
Well, before I can see anything, you have to show it to the attorney. So I'm going to have the two of you go back out into the lobby so you can show them the videos so we can determine if it's even something that's relevant that the court needs to even look at.
Can I ask a question? He's showing the video of the prior unit he lived in. And
that's what we're
regardless of the situation, and even if my client didn't repair, which they claim that they did, still does not allow him to live where he is without paying his rent.
Counsel, I'm not suggesting it does, but he has some evidence he wants the court to look at. So before I can look at it, he has to show it to you.
Okay.
So that's why I'm asking for the two of you to go out in the lobby to see if that's even relevant or not. Okay?
Yep.
Thank you.
That's the question.
Yes.
After I show him the videos, how do I get him to be able to let you see it? What do you say I do? So you want me to screenshot it? Or
No, you have to screen share. You would have to log into Zoom and screen share. However, any evidence that you want this court to look at, you were supposed to have shared with the attorney prior to today.
I didn't know.
Well, I'm fairly certain I stated that when you were all last here on the record. So are there documents that you want the court to look at also, or is it only a video?
There are videos of the people that came in to try to work on the stuff.
Okay, so videos. Okay, all I need to know is videos. So counsel, please go out and look at the videos and see if any of those are relevant to today's proceedings from your perspective. Thank you. Sir, do you have a problem?
Are you talking to me?
Yes. You're walking out because you sighed and said Jesus, like you're frustrated.
I am frustrated, and I did sigh and say Jesus. That doesn't mean I obviously have a problem, or we wouldn't be here. Yes, I have a problem. Yes, I said Jesus, because this is ridiculous. He's going to go out there, look at my videos, say it doesn't matter, and we're going to come back in.
Sir, first of all, here's what's not going to happen. What's not going to happen is there's not going to be hostility between the attorney and yourself.
Hostility.
Sir, excuse me. Let me finish. There is a procedural evidentiary requirement that if either side wants to present evidence before the court can see that evidence, it has to be disclosed to the other side. So you have to show Mr. Katz the videos that you want this court to look at. Let's not presume what's going to happen. Okay? Mr. Katz, is there any evidence that you want this court to look at?
Probably just my client's been testified to the amount that it currently owes.
Is there any evidence, any physical evidence, any exhibits or otherwise that you are going to want this court to look at?
Potentially.
Okay, then please share those with Mr. McKenzie. Mr. McKenzie, we are not doing this. All right. I just stated that Mr. Katz is required to show you what evidence he wants to submit to the court.
He just came in front of me now, so again, for some reason, I guess to do it in front of you, he did it out there, he saw the paper, he saw some of the videos. And then we got into
Oh no, I could hear all the way in here.
He has this notion of not even, he didn't look at all the video.
Hold on, just one moment. Mr. Katz, how many videos are there, Mr. McKenzie?
There's like 15.
15 videos.
Yep.
And you didn't send any of those over to Mr. Katz before today?
I sent them, not to him, I sent them to the email of the managers.
Okay.
He never said a word to me.
Sir, let me just explain something to you. Just because you send them over to the managers doesn't mean those are getting to the attorney. The rules of evidence require that people representing themselves or attorneys need to exchange the information or the evidence that's going to be presented with each other.
Try to show them to you.
Mr. Katz, how long is each video, sir?
Like 30 seconds, a minute, maybe.
Okay. Mr. Katz, how many videos did you look at?
Your Honor, I looked at 3 videos. He showed me videos that relate to his old apartment.
Counsel, I instructed you both to look. I instructed you to watch the videos. If he has 15, you have to look at all 15 of them.
Okay. Your Honor, again, I started talking to him about the fact that I said, we're here for an unpayment on case. I never showed him, by the way, the document that I just showed him just now in court. I never had an opportunity outside because I was watching the videos first. So I hadn't shown him that paper. So when he said that I came to court to just show him that I showed it to him, that was the first time I got to present it to him, because I realized when I came to court, into the courtroom, that I had yet presented that to him. In the middle of the videos, I said to Mr. McKenzie, Mr. McKenzie, I just want to ask you a question. You haven't paid any rent for the unit that you're in.
Okay, so just one moment. Hold on. There's only viewing of the videos. There's zero communication. Zero. Go out and look at the videos. There's no communication between either one of you right now. Okay? Just look at the videos that he wants this court to look at, counsel.
Okay.
And there's no communication. There's no comments. There's no huffing, puffing, nothing.
I just want to get my dates correct, just so I
Okay.
the areas as it relates to what I was presenting.
Okay. Let's go on the record in the matter of residences on Penn for Sandy McKenzie, 2501895. Mr. McKenzie, you're going to come up here to this table, please. Let's go. And counsel, your appearance for the record, please.
Good morning, Your Honor. Sidney Katz on that plan.
Okay. And Mr. McKenzie, your name for the record, please.
Stanley McKenzie.
Okay. So just typically you'll stand up when you address the court. Okay.
McKenzie.
All right. Thank you. And so, counsel, today's the date scheduled for an in-person hearing. This court, on November 10th, this court held a hearing. It was the first hearing. The court does recall that the issue here is for non-payment of rent, that Mr. McKenzie was relocated while the plaintiff was performing repairs on his original unit. And so this court ordered all parties to be here in person today. And my notes specifically say, bring all documents from the prior unit defendant was evicted from and the repairs that were allegedly done. So, did you bring those documents, Mr. Katz?
Oh, I did, Your Honor. I brought my client here as well.
Okay. Did you share those documents with Mr. McKenzie?
Your Honor, there really are no documents to share. we moved someone into that unit. My client has, I have an invoice from the party that basically did the work. It's
Did you share that with Mr.
I did
McKenzie?
not, because I don't know if it's here, it's McKenzie.
Okay. So, counsel, you have two individuals that are here with you, and what are their names? No, counsel, I'm asking you what their names are.
Melissa White,
Shala
Shala Haynes.
How do you spell their name? How do you spell Shala?
Halla.
And the last name, please.
Haynen.
Okay. So they're both intending to testify, counsel?
Possibly, Your Honor.
Okay, so then we're gonna have to have a sequestration so that there can be clear and clean testimony from each individual. But what I will do though is I will have Mr. McKenzie, Ms. White, and Ms. Haynes all stand up, please, and raise your right hands. Solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, nothing but the truth. Mr. McKenzie,
Yes.
Ms. Haynes,
Yes.
Ms. White. All right, thank you. So Ms. White and Ms. Haynes, you're going to have to go out into the lobby until Mr. Katz decides who's going to be testifying first. It's called a sequestration of witnesses. So there can be clean testimony from individuals. And in the event that it's live streaming somewhere, you can't watch the live stream. And so okay. So as I recall from, I believe it was just Monday when you were all here, Mr. McKenzie was in one unit, and which was which unit number, counsel?
Your Honor, that would be unit
201.
14945 Brookview, apartment 201.
Okay. And so then there were some repairs that needed to be made, correct?
Correct, Your Honor.
Okay. And so then from there, your client moved Mr. McKenzie to which unit? Same building, just a different floor, correct?
Correct.
Okay, what unit?
This one was apartment 101 in the same building. And that was only the bathroom that they were giving them access to.
I'm sorry, what?
They had contractors working on the bathroom. They basically said, because the bathroom is going to be down, you can utilize the bathroom in the unit 101. And there's one more job.
When did the repairs, when was the communication given to Mr. McKenzie that he could utilize the bathroom in unit 101?
I know that would be sometime around September the 12th, Your Honor.
Okay, is that accurate, sir?
Yes.
All right, please keep your hands out of your pockets. And was that permission given in writing or orally, counsel?
I believe it was orally, Your Honor. It was given by my client, and I've asked them if they have anything in writing. But they weren't able to locate anything in writing.
Okay, and so how long did the repairs on the bathroom in unit 201 take?
As far as I'm aware, it was supposed to be over that weekend that they were going to be doing the primary work. So
That wasn't my question, counsel. My question is, how long did the repairs take?
I'm guessing, Your Honor, probably a week.
You don't know that information from your client?
I don't know the exact specifics. I just know when it was supposed to have been completed by.
Well, supposed to and when with contractors are definitely two different things.
Yeah, Your Honor. Now there were some items that were punch list items that were not completed until after Mr. McKenzie moved out, which includes painting and just basic cleanup work.
In the bathroom or somewhere else? Basic cleanup work. What does that mean?
Debris, just items that were final punch list items, Your Honor.
Okay, counsel, let me just clarify something, right? I'm very much familiar with construction and punch list items and all that stuff. All right. You have a contractor that was repairing a bathroom. And then you are telling me that there was still basic cleanup work to be done and painting of the bathroom. Now, I imagine the bathroom isn't very large. So, and by very large, I mean like a walk-in bathroom, not a walk-in bathroom, but like a master bathroom type situation. It's an average bathroom, correct? All right. So, Mr. Katz, what were the repairs that were to be done in the bathroom?
There were some leaks, Your Honor.
Okay, leaks, toilet leaks, shower leaks, sink
Shower
leaks.
leaks. There was some mudding, replacement of drywall, mudding, painting.
Okay, what else?
And then cleanup.
Okay. So the leaks were repaired, correct?
Correct.
And the drywall was replaced
Correct.
and mudded.
Correct. It has been mudded, but I might have been only after Mr. McKenzie.
Okay, Council, let me be very clear.
Oh no.
While Mr. McKenzie was the tenant in that unit,
Yes.
was the drywall replaced?
Yes.
Was it taped?
I don't know if it was taped, if it was fined, Your Honor. That's the point. That's what I'm saying. Because I do have an invoice from the contractor dated 10/3 for the which was the final on the rehanged tape and mud. So it's possible. I believe that the mudding was done and the taping was done. I don't think that they finalized the painting until after Mr. McKenzie moved out.
Okay, so the only items that were being repaired for Mr. McKenzie was the bathroom.
Yes.
There weren't any other items in the apartment that were to be worked on.
Not that I'm aware of.
Mr. McKenzie, were there any other repairs that were to be made in the apartment other than the bathroom? Yes or no?
Yes.
Where?
The washer and dryer is located in the bathroom because there's a little wall that divides it. The washer and dryer was ruined from the leak, so they had to take it out and get a new one because the water went into the back of it and shortened it up.
Okay, so the washer and dryer were to be replaced.
Yes.
Is that accurate, Council?
I don't know if they were to be replaced, but I know that it was in the bathroom, as Mr. McKenzie indicates. So all the work that was to be done was in the bathroom.
Okay, so Mr. McKenzie, was there any other work in the living room, the kitchen, the bathroom, otherwise that needed, the bedroom, that was to be repaired, or only the bathroom?
The bathroom is where all of the problems were.
My question is, sir,
Yes.
were there any other rooms in the apartment?
No.
Okay,
I have
hold on, sir. When were the repairs set to take place?
Is that for me or Mr. McKenzie?
Either one.
I believe the week of September the 12th. September the 12th was a Friday. And so they basically had contractors who were supposed to be out there that weekend. So they told Mr. McKenzie he can go and he can utilize the bathroom in the unit below. And that was the weekend that they were supposed to be doing the work, which is when I believe they did the work.
Okay, sir, was there a conversation that you were permitted to utilize the bathroom in another unit while your bathroom was under construction?
yes.
Yes or no?
Yes.
Okay, very good. And so would that be accurate, September 12th?
September 12th is just when they got there. Well, they were supposed to start right after we left here when we saw each other last, and they did not start until 2 weeks later.
Saw each other last. You're
When
here.
we came into the court.
You're here November 10th.
No, back then, the last time that we came in here before that, I'm sorry.
Okay, so
And they didn't start until 2 weeks later. They came and cut a hole in our ceiling and left it there
In the bathroom.
in the bathroom.
Okay,
We're-
so pause just for a moment. So was that September 12th or not?
No, when they cut the hole, no.
When was the hole cut?
The hole was cut probably the week before that. I'm sorry, 2 weeks before that. Actually, when is the last time we were here? I don't know the exact date when we were here. When you told them that they have to do the repairs for the third time, they came in after that and cut a hole in our ceiling and just didn't come back for 3 weeks. And then when the videos that I showed him on the 11th is when they came back and started, and he just said that was right. The 12th they didn't. They had already ripped down the ceiling and the walls and pulled out the machine, the washer and dryer. As he saw, once they cut the hole over the shower, that was where the biggest hole was from the leak. But they left it. They never came back. And that was different people. I guess they quit or got fired or whatever. 2 new guys came on the 11th, and they are the ones who tried to cut into where they were, the last hole, and realized that the whole ceiling was rotted and the walls were rotted. And the back of the machine had rust and all the water. When they moved the machine out, the water just spilled. I think I was on video with you when I told you the first time the water splashed on me.
Okay.
This time when it splashed on them, it came over.
Okay, just a moment. Mr. Katz, are you familiar with that?
I'm not familiar, but Your Honor, I do have to ask the procedural issue because here's where I'm sort of confused is it relates to this. Assume you gave him 100% abatement on his old unit, okay? 100% abatement on his old unit. He's living in a different unit. He hasn't paid on that unit. If he pays the $5,200 my client is claiming that we're here for, okay? Remember, he said he was going to put money in escrow 4 times in court with the prior hearing. No money has ever been put in escrow with the court. If he got full abatement on the prior unit, okay, which I don't think he's entitled to, but let's say he did, he hasn't made any payments on the existing unit. If he pays on this case for the existing unit, which he has no issues with, Your Honor, then he could stay in his current unit technically by law because we filed this as a non-payment as opposed to a termination of tenancy.
Okay, so just a moment. Sir, you're living in 101, correct? You moved all of your items to 101.
Yes.
Okay. Have you made a rent payment?
No.
Why not?
Because we were told that we were only going there because of repairs that were being done.
Hold on.
First,
Listen. When is the last time you made a rent payment, sir?
I haven't paid rent since we moved in
Why not?
because of everything that we're here for. The bathroom is completely ruined.
Hold on. The current bathroom that you moved into?
The current bathroom that we moved into is absolutely rotted, just as the one we were in before.
So, sir, so tell me, okay, you haven't paid rent to your landlord. What escrow account is your rent in?
I had an escrow account as we came here the first time, and I told them that, and we were thinking that they were going to get everything finished. Once we realized that after 2 months, nobody had come in.
Sir, you're not answering my question.
I had
Where's proof of the money in escrow?
the proof of the money in the escrow is in my account.
Great. You need to show where that rent money is sitting.
The rent money is still sitting there.
Great.
Because we were about to move.
Pull up your bank account. Pull up your bank account.
I can't pull up
Your
my
Honor,
bank account.
if I can-
I can go and get a statement, which is what I was supposed to be talking to him about. You told us, you said, we won't even have to come back here if you two come to an agreement about moving in or if you're going to get paid. I told him that I was going to be out of there by the 1st. He said, okay, if all you have to do, if you don't pay us, then you have to be out. I said, yes, we plan on moving on the 1st. We couldn't move on the 1st.
1st of November?
It was October. We couldn't move on the 1st because we got after you gave them the default victory, we got a eviction notice. We go back to the place we're about to move into. The lady says, no, you have an eviction notice. You can't move in.
Sir, you've now been living in a spot that you are living in and you haven't paid rent.
I'm not paying rent for something that these people ain't never fixed. And the house that we in now, it's still rotting.
Okay, then, sir, you are required by law to show proof as to the money being in an escrow account, a separate account or otherwise. You have yet to show that proof. How much money do you have set in that separate account?
The separate account is $7,000.
Your Honor, if I can.
We were about to get it shown.
When we were here in August, you asked to send me, you said he has to send me a copy of his escrow account. He didn't. We spoke in court the next time. You said, send him a copy of the escrow. He didn't. I sent him an email on September 12th. I followed up on my conversation with.
Excuse me, just one moment. Did you respond to the email? Excuse me. Let me finish my question. Did you send a response to Mr. Katz's email with proof of the rent money sitting in a separate account?
I just said no.
Okay.
Because he didn't send me an email that you can't respond to something that no.
All right, counsel, I'll take a look at that email. First, you have to show.
I'll show it to Mr.
Well, no, my court officer will do that. Thank you. Thank you. Do you, okay, but there was another one filed in August.
Are you on it on my phone?
Nope, I'm on this current one.
Okay.
So you should be able to get it out of the other one if you can.
Okay.
Yeah, thank you. It's the one that ends in 946, sir?
That's one of my emails, yeah. I didn't get that email.
How many emails do you
I
have?
have 2.
Okay. When you say you didn't get it, what does that mean?
I didn't receive that email.
Did you check your email?
No, I didn't check it. I never knew he sent it.
Well, sir, it's your responsibility to check your emails.
No, I mean, I checked my emails and I didn't see nothing from you.
Good.
You
Grab your phone. Grab your phone. Grab your email. Terry, can you please watch him pull up his email with this one to look back on September 12th, please?
And Your Honor, I did follow up with a call to him. I tried to call him multiple times.
All right, just a moment, counsel.
We spoke one time on the phone.
Right now, we're just going to have you look for your email from that email address on September 12th.
And Your Honor, just for the court's record, Mr. McKenzie.
Hold on, counsel, please.
Here's the email from me. He said he sent it on September 12th, right?
Yes. 2:37 p.m. Is that the one that ends in 946?
Mhm.
All right, Mr. Soap, I'm going to make you also a co-host because you have individuals that are checking in, so you can move people in and out. You'll be back into breakout room 3, I think I have you.
Yeah.
So Miss English is present. I just let her in. Same with Mr. Parker.
Okay, I'll go meet with them now, Your Honor. Thank you.
Thank you. So thank you. Can you, no, I'm sorry. I wasn't very clear. Can you go into the My File
Okay.
and print out?
The case.
Yes, thank you. Is it showing on there?
It's buffering to get to it.
The connection is very small.
Okay. Okay, what else is it you wanted the court to know, counsel?
So Your Honor, again, Mr. McKenzie was informed at least, I think, 3 or 4 times with the court to present the court with the copies of the escrow and to present me with the copies of the escrow. He never did, as it relates to this prior case. He has yet to show any evidence, and he's had ample opportunity from August of this year. In addition, he was moved out of his unit with an $8,700 balance on his prior unit. So on top of the fact that he now owes over $5,000 on the current unit, he's been living, has basically a $13,000 balance with my client.
All right, counsel, just one moment. What the balance for unit 201 was how much?
$8,680 was the final balance.
Okay, final balance. What does that represent? How many months of unpaid? How much is the rent per month?
The rent per month is $1,000. $499. There's additional charges of trash, gas, pest control, water, which total around $120 to $130, it looks like, per month. And then they actually prorated him through the date that he was actually evicted out of that prior unit, 10/6, 2025. So his only payments, he moved in on April the 30th. The entire time he was there, his payments equaled $1,613.72.
Okay, so that's how much has been paid since he moved in on April 30th, correct?
Correct, except for an application deposit of $150.
Okay, so let me ask this question, council. $8,680. That's $14.99 per month in rent plus the $130 per month in extras. That's for May. No, that's for June, July, August, September. When you say final balance, what else is on that final balance?
There's no damage included on this that I see. There's late fees each month for non-payment, so
How much are the late fees?
$100, so $500 of late fees, it looks like. And
$100 per month in late fees?
it started in September and in October, so it would be 6 months of late fees. And then violence.
Well, so if he moved in April 30th and he paid a month of rent, that would be for the month of May, correct?
Correct.
All right, so June, July, August, September, that's 4 months. So $1,629, which is the $14.99 rent plus the $130 in extras for 4 months is $6,516. Plus 4 months of late fees is $400. So
6 months of late fees for
council, right now I'm just going on unit 201 right now. I'm going June through September. Because June, July, August, September. So that's $6,916. And you said then there was a prorated amount for October for 6 days?
correct. So it looks like actually they did not. They actually recharged it. So actually the whole month of October is in there. See, they originally
Okay.
and they put it back in.
Okay.
So that would account for that difference.
All right. That would plus the $100 late fee. Okay. All right. So, Mr. McKenzie, did you pay rent for the month of June? Are you on your phone, sir? Or are you still looking for the email?
I'm looking for this email that don't exist.
Well, it exists, sir. Whether or not you received it is my question. That's why I wanted you to show my court officer there, but I don't know if it's continuing to buffer. What date are you on?
We only back 4 days.
Oh, okay. Wow. Sir, let me ask this question. Let me ask you. I'm not questioning whether it's buffering. Okay, please keep your hands out of your pockets. Did you pay rent for the month of June?
I paid rent when we first moved in.
Did you pay rent for the month of June?
No,
Did you pay rent for the month of July?
no, I didn't pay any rent except for the first month when we got there because they never fixed anything.
Okay, so, sir, it is your responsibility per the law to show the court and your landlord that you are depositing the rent in a separate account. That is what the law requires.
Yes.
You have not done that. I'm not questioning whether or not the repairs were necessary or not. They clearly were necessary because they were made. They were made. You did not submit proof of the escrow amount as you are required to do.
And they didn't fix anything as you told
Sir?
me they were required to do.
Sir, just let me.
Yes, sorry.
They did not fix what they were supposed to do. They finally did it in September. That does not negate your responsibility for showing proof that the money is deposited in a separate account. Had you done that, we wouldn't even be here because you have that requirement. It's a legal requirement that legally allows you to withhold payment of rent for repair issues. You did not submit proof of that. And the court will also note that July 25th, on the prior case, 2501234 LT, that you claimed many repair issues. We set it for a second hearing August 11th at 8:30. On August 11th, there is no agreement on the amount owed. Plaintiff claimed 5151 was owed. We set it for an in-person hearing August 22nd at 11 a.m. The court also on August 22nd stated that there was a hearing, there was information gathered. Parties were to return September 15th at 11 a.m. Defendant to be included in any communication regarding scheduling to look at the apartment and repairs to occur. Defendant to submit proof of rent money held in account and activity of deposits by August 27th. Did you do that?
And
Okay. Then on September 5th, and everybody was supposed to return September 15th. Oh, sorry. Also on August 22nd, Gold Star Restoration was to be at the apartment that day between 12 and 5, and the court had ordered the parties to go in the lobby to determine if they'd already been dispatched to the apartment, because I recall that that was a concern that had occurred. Now, then let's move to September 15th. Mr. McKenzie, you were not present. Also, you had not shown proof of the money escrowed by August 27th. The representation on September 15th was that all repairs have been made and near completion. Drywall being completed September 16th. That's when the court entered a default judgment of $6,856 with a writ of September 25th. And the abatement was not addressed as you did not appear and you did not speak with plaintiff counsel regarding any abatement. Sir, had you appeared, the court would have known
that they didn't fit.
that it wasn't finished. Because the court took what counsel represented. Now, whether or not counsel spoke with their client ahead of time, I have no idea. The court has to go with the representation as an officer of the court that is all being done. Further, the court then, so there was a judgment entered appropriately. There was a judgment entered because you weren't here, sir. I don't know why you didn't show up, but you weren't here.
That's what I was talking about in the last Zoom. I didn't show up because I had asked if we could change to another day, and you said no. And I said I had to work that day because I drive longer, so I couldn't be here because I was out of the state. And I remember saying that I was like, "Can we please do it another day on the Zoom?" You said, "How come we didn't do it on Zoom?" And I said, "I don't know why we didn't do it on Zoom." But you said we had to be here that day. And I couldn't make it that day. And I let you know I couldn't make it that day.
Sir, when did you send something in writing? Because listen, I have hundreds of people that speak to me in a day.
Oh no, I didn't.
Hundreds of people that speak to me in a day. Okay. And so while I have a fairly good memory and recollection of many things, I don't recall every single conversation with every single person. You were not here on that date. You didn't even Zoom in or anything. Okay. So the court entered a default judgment.
Right.
Clearly there was a misrepresentation or misunderstanding somewhere because the repairs were not done as counsel represented they were.
I had talked to him.
In any event, sir, you did not show proof of the money deposited in escrow. Had there been proof submitted to plaintiff counsel would have been required to notify the court, show the court, and the court likely would not have entered a default judgment against you, sir. But that didn't happen. And now you're occupying another unit and not paying rent and not showing proof of that money sent into escrow. So, sir, let me also clarify something. Back in July and even August, I could have ordered you to submit that escrow deposit with the court. And if you didn't, then there would have been additional violations. Counsel, you on your phone?
I'm just checking the date, Your Honor, because
The date of what?
Your Honor, I'm almost certain that when we scheduled the date with Mr. McKenzie for that September, what was it, the 15th?
15.
You actually chose the date because Mr. McKenzie indicated what were the best dates for him. Okay?
I would agree. I'm pretty sure I did.
We modified the court dates specifically based on Mr. McKenzie's AM, PM, and whether he was working that date. So Mr. McKenzie says that he told the court that he wasn't available. I am certain, Your Honor, that on the date that we scheduled, it was scheduled with him in mind and with his schedule in mind.
I agree. I would agree with that because I was being very careful to make sure that Mr. McKenzie was able to be at these hearings.
I asked you about that day. I said, can we do any other day? And then you said no. Now, on the last Zoom we had, you said, how come we didn't Zoom? I Zoom when you say Zoom. I come in when you say come in. So if you didn't tell me to Zoom that day, it's because I don't know why. But I have certain days that I drive. That was a money day. So I absolutely know that I came to you and told you that before. Why would I miss that? There's no way that happened. So,
Sir, let me just clarify. I do recall that when selecting these dates and times, the court did take into account your work schedule.
I know exactly why. Because when I was going to show up to the at home, every time they were supposed to come out and fix things, it never showed up. You said, you talked to them, how come they didn't show up? And I said, I'll be missing days of work to stay home waiting for these people to show up, because that's when they said, we don't know when they show up. They just show up when they show up. That's literally what they said. And I said, I stay home from work and miss work, wait for these people, and they never show up. And you tried to make an accommodation, and I did everything.
All right.
Except for that day the Mondays is a money day that hasn't changed in 4 years.
Sir. Okay. Irrespective of all of that, your legal requirement of showing the money deposited into a separate account has not been met. And further, I even ordered that you had to show proof of the deposits that had been made to show that every month you were depositing money into this account in lieu of paying rent. You did not do that.
So when
Sir, you did not do that.
I said, no, I didn't. No, I didn't. You're right. And you told us that if we came to an agreement that we wouldn't even have to come back here. I called him, told him that when we were going to be out, and he said, okay, just show me that thing that you just said, the paper. I said, fine. That day came for the 15th. I called him before that. Now, this is what we had a disagreement with outside in the lobby. On the day that I was calling, he had a message that says he wasn't returning calls or texts or something like that. I called the manager. She called and said, well, he's not answering available. Same message that I got. She said, I'll let you know, but I want to call my boss.
Okay, sir, hold on just a moment, please. Just a moment. What date is all this occurring? This that you're talking about right now. What's the date?
Exact date.
Well, I need to know that because from August 22nd until September 15th, I'll tell you I'm sorry?
It was between then, before the 15th. And this is the reason why I was saying that. The reason I called him to make this agreement is because I knew I was not going to be there on the 15th. That's why when he says, oh.
Sir, just one moment. Please listen to what I'm saying. There's 3.5 weeks in between the court dates.
Yes.
So in 3.5 weeks, you did not send that to Mr. Katz.
No, I didn't.
Okay. So, sir, that is the whole crux of the entirety of the case at this point. There is zero doubt that there were repairs that need to be made. The court also doesn't have any doubt that those repairs were made while you were the tenant of that property.
Yes, never made while we were.
Okay, and you never showed proof of your deposit.
Right.
Which you are required to do.
Yes.
So therefore, the court doesn't have any legal basis to not grant the plaintiff's motion or the plaintiff's request for judgment, sir.
So if I was to bring it in or mail it to you or give it to him, to y'all both after this, what would that do? Would that make it to where my problem that I have now is that that default judgment put an eviction on my record and I can't move into somewhere else because they see the eviction from this place when I should have been evicted, when they never fixed anything. My house is like construction.
Sir, then you should have followed the court order. You should have followed the court order and sent proof of that to Mr. Katz.
They didn't
And
follow the court orders either.
sir,
And I'm the only one getting punished.
sir, the property has now been repaired.
It's not.
The one, unit 201 is what I'm talking about.
They still
201 appears and is represented to have been repaired. Now, if you wanted this court to take into account abatement amounts, as it was going to do, then you needed to submit proof of the deposits of the rent to Mr. Katz. You did not do that. And in fact, the court ordered that on August 22nd, sir. August 22nd, the court ordered that. You did not do that. You did not do that in August, September, October. And now here we are, November 14th, for an in-person hearing, and you don't have the documentation with you yet again today. So, sir, while the plaintiff's potential for having a violation of a lease for not repairing the items, that's a separate issue as well. What we're here for, sir, is that you did not pay rent. You did not show proof of your unpaid rent being deposited into a separate account. That is how you are legally able to not be responsible or not be evicted for that purpose. You did not do that. 4 months. 4 months, you have not done that. So, sir, that is why this court has to enter a judgment against you for non-payment of rent.
Yeah.
Because at this point, it's the plaintiff's inability to repair their units timely is not as much of an issue at this point because you did not show the proof of the escrow accounts. And that, as I stated, is the only way that you can legally withhold rent. And that did not happen. And sir, there were multiple opportunities for that to have been shown.
You're right. Thank you for giving me those opportunities, and I didn't show it to you, and I was upset, and I'm still upset, and I wasn't going to. I should have brought it to you, like you said. I'm sorry about that.
Now, sir, let me also be very clear that because there's judgment that's going to be entered against you doesn't mean that this court doesn't have concerns about the plaintiff having things repaired timely. Okay, that is not the case. But as I stated, the only way that this court could not rule in favor of the plaintiff is had you shown that. So the court is going to enter judgment for plaintiff.
And your energy house. Because the old balance is irrelevant. I'm fine waiting up to file a separate case.
So this is only for October?
This is for actually October and November for the current unit, which they indicated to him. They posted the amount he would have to pay if he remained in that unit. The monthly rate on that unit is $2,500. So he owes $5,000.
The monthly rate is $2,500? Hold on, just one moment. Counsel, how is it $2,500 when the unit right above it is $1,499?
Because he has no lease, Your Honor. And basically, he was not provided access to that unit other than the bathroom. So there was a notice that was put on his door that said, if you remain in this unit, you will be obligated for $2,500.
Okay, can I see that notice, please?
And I showed it to
Terry, can you grab that, please?
Yeah.
He saw it.
Well, hold on a moment, counsel. When did the new tenants move into 201?
The new move into 201. Actually have the date of that. 10/27.
October 27th.
Correct.
And I believe your statement was that the bathroom wasn't completely finished until after the new tenants moved in, correct?
No, until after they moved out of the final painting and final work and cleanup of the unit was done after October the 6th, Your Honor.
Okay. Well, counsel, I'm not going to authorize $2,500 per month because this states, this notice is to inform you that the temporary use of apartment 101, which was granted solely for bathroom access during the restoration of the bathroom in apartment 201, is no longer authorized. As of today, the bathroom in unit 201 has been fully restored and is fully functional. It was not fully restored. Not by a long shot was it fully restored. So this is not, the court's not going to authorize $2,500 a month. So the court will go on the same rent as it was in 201, which is $14.99 a month plus the $130 a month in extras, correct?
Correct. Plus the late fees since then paid.
So $16.29 times 2 months is $32.58 plus the late fees of $200, $34.58. Correct, counsel?
Plus, yes, cost of 180.
$180 for court costs.
It's 38.
$3,638 is the amount, the judgment.
Your Honor, the stuff that was supposed to be fixed upstairs at our old unit, it's still not fixed because the water is still leaking down to where we are now. And I wouldn't say nothing about it if it wasn't that I called Riverview Housing Department because they had to come do an inspection because there is mold.
Did you submit that in writing to the plaintiff?
Oh, no, those are the videos he just saw. And
Did you submit, sir?
I didn't write nobody about it.
I believe in your lease, if you look at your lease, you need to submit repair requests in writing. I would presume. I think that's typical of any lease, but I don't know this particular one. So I understand you may make a phone call.
Yeah.
But
So then they do the thing. Or ticket they call.
emailing is probably the most effective way to make sure that there is a chain of communication. But again, sir, you haven't put any money into escrow. So even if you notified them on the new unit that you moved into that there was a repair issue, you are still required, if you're withholding rent, you are required to notify them you're withholding rent and proof of the escrow account, right?
Yes.
And that didn't happen. I'm already not assessing the $2,500 per month because that was a misrepresentation. The unit was not fully restored. And nor was it anywhere close to being done when the parties were here back on September 15th, indicating all repairs have been made and near completion, drywall being completed tomorrow. So apparently near completion is a subjective definition. Because counsel, let me be very clear. Had I been informed properly that the repairs were not all finished and not near completion, it may have been slightly different. So as counsel for the plaintiff, it's your responsibility, counsel, to communicate with your client to get specific information. This court requires details, specific information. Even as simple as having the names of your witnesses to tell the court. The court's going to order, after hearing that judgment is for the plaintiff, $3,638. If the amount is not paid, defendant does not move out on or before November 24th, plaintiff will apply for an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant. No money judgment at this time. Good luck to you both. We'll make sure you get those back, sir.
Your Honor, do you want the copy of the judgment or do you want me to just submit it, Martha?
You can submit it via my file. Thank you. Good luck to you both.
Enjoy Mr. Borkin. He's handling all the stuff.
Yes, yes. What's that?
Sorry for getting upset.
It's fine. You're fine.
Sorry.
Oh, you're fine. Thank you.
Fixed housing 401k plan versus Erica Ward. And it should be Erica Ward and Aaron Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing 401k plan.
Donna Tope on behalf of Eric Ward and Erica Ward. Tenants on the lease.
Okay, where are we on this case, folks?
Your Honor, so the last time we were here, if you need me to get into that, you denied defendant's motion to stay the eviction
Correct.
and transfer the eviction case to the circuit court. You ordered tenants to produce a full accounting with receipts of money placed into Ms. Tope's escrow account
Yes.
and of transactions made for repairs and purchase of supplies. You also ordered prorated November rent and rent going forward into district court escrow.
Correct.
We had a hearing on Wednesday on the circuit court action.
Yes.
And as you recall, plaintiff or tenants brought the circuit court action. We filed right away a motion to compel payment of rent. And the circuit court denied our motion for lack of jurisdiction, basically leaving it for you. Your Honor.
They did?
Your Honor, we don't.
Who was that?
Judge outside.
Okay, thank you.
She's retiring.
Pardon?
She's retiring.
I understand that,
Yeah.
but,
She didn't want it.
no,
Your
that,
Honor.
no, never say judge outside never wanted to deal with it, because that's not it at all. If she felt this court had jurisdiction, that's what she felt.
Exactly. Your Honor, I have transcript from Wednesday's hearing, if you'd like that. Or do-
I may need it, but hold on. So that was denied. And so the rent issue is now landed firmly in my lap.
In this court, correct.
Okay.
We can go into the accounting if,
Do I have an accounting?
Yes. Filed it on Monday. November 10th. With receipts, and the last page is the final accounting as of that date.
This is the one with the invoices attached.
Yes. You asked for,
Oh, no, I know what I asked for, but go ahead. What were you gonna say with regard to the accounting? I see this document. Go ahead.
Your Honor, one procedural point. We only received a copy of the accounting because it was e-filed in the circuit court. So I would say service would be improper for the accounting for this court. But I would say to be frank, the accounting is a mess and it's wholly inadequate. I have many questions for Ms. Tope, which I think really highlights the problem here that opposing counsel has inserted herself into this litigation. As the court correctly stated last Friday, there's no legal authority allowing opposing counsel to handle and disperse these funds to contractors and for supplies, especially when these funds were owed to my client under the lease. At
hang on a second, Council.
Yes.
Ms. Tope,
Yes.
I'm going to ask you a difficult question. I may stop you from answering at some point because I'm not trying to bait you into anything. But these individuals are your clients who, and you're their attorney. They, at some point, gave you funds, right? Were the funds placed into your IOTA?
No.
Oh,
Can
got a whole other problem. Because,
Your Honor,
yes,
let me start at the beginning.
no, you're not going to start at the beginning.
Your
Because, no, you're not going to start at the beginning.
this
This Tope. You know what? You say, oh my goodness, one more time, and I'm going to find you in contempt. I'm stopping you from committing a grievable offense. That's why I told you at the very beginning that I may stop you after my answer, after you gave the answer. Because you have a tendency, when I ask you a yes or no question, to continue to go on and on. And you are going to get yourself in serious trouble. Very serious trouble. I ask specific questions for very specific reasons because at some point, here's going to be the problem, Ms. Tope, and I'm just going to lay it out this way, and I'm going to try to lay it out without placing any sort of finding or what I'm thinking. If you, as an attorney, are given funds by your client, you must hold those funds in trust. That is typically done through an IOTA account, particularly if you are then dispersing your client's money on their behalf to third parties, to others, or corporate, whatever it is. You then have to have an accounting of that. Moreover, when I start looking at the dates, at some point, these would be required to be reported. Yes, I'll just leave it there. You're going this intake and disbursement on the face of it had to be done in a particular way. Now there may be something about the transaction that I don't know, but on the face of it, that's what it looks like.
I totally understand what you're saying. Our case filed before the circuit court was filed on July 9th. They had jurisdiction of that breach of lease case. Part of the breach of lease case was that the landlord did not make necessary repairs for the health and safety of all those who were benefited by the lease. We notified them in that case that we would withhold that. They had been requested to make the repairs. They had declined since 2023. We had to make them for the coming winter for the horses and the people that were there. We notified them in August that they paid the rent in July. We notified them in August that we were going to withhold rent and to make the necessary repairs themselves, mitigating, trying to correct the problem. They filed their summary judgment here in this court, which I agree, under a summary judgment, a trust fund would be set up. When they filed on October 20th, this was after months of making repairs.
Stop.
That's when this court got
Getting things confused.
Pardon?
Getting things confused with what I'm saying and with what you're trying to argue.
Mhm.
I get with reference to any escrow order that the court initiates.
We asked for them.
It's what you did before that, Ms. Tope, that I see as being problematic. You're acting as an attorney, and I'm just going to say this again, and you take into your possession client funds and then disperse them. So I'm going to put it in the most general sense I can. That has to be done in a particular way with certain accounting that comes with that and certain accounting that must then be reported. What is, well, I'm not going to say it's clear to me because I will say I have very serious concerns as to whether or not that happens or happened. Which, Ms. Tope, may, I'm not saying will, may subject you to certain liabilities, potentially with the state bar.
That would be because of the circuit court case.
So, I'll be honest with you, I'm not the one that you're going to have to explain it to. I mean, but I'm doing my best to say that on the face of what I'm seeing, you may be in jeopardy of some adverse consequences because of what's occurred. That's what I'm saying. What I'm also saying, it's troublesome from the court's perspective because when you refer to you and your clients and certain things that have been done, and this is what happened, and I hate bringing up other cases with reference to present cases, but you keep referring to we in terms of your clients and you acting. Sometimes that is absolutely appropriate, and I don't just, it just is. It's just language. Part of the court's hesitation when you are saying it that way is that, and again, I'm saying this and I'm not making a finding, but if you were operating, I'm going to put it in form of a hypothetical, and I hope you can follow it. If your clients were following your advice to place the monies with you and then pay the money out, where that may be in violation of the plain language of the lease, right? They may have a claim, whether they choose to pursue it or not, as to you.
I understand what you're saying.
And so that's a problem for the case proceeding. Because you can't be, you're representing them, but as to the position that they in the business should take, on the face of it, when I look at it, you have a conflict in terms of that. And outside of the fact of the first thing that I said, where you might be in violation, and I'm not saying you are, and I hate even making the accusation of ethical rules that would apply to attorneys taking clients' money into trust.
I understand.
And again, I will give this blanket statement. I am not saying that making any accusation. I'm not making any finding. I'm not saying any of that. I'm not saying even to a great extent my analysis, if I were to come down to the end of it, is correct. All I'm saying is that's what I see on the surface.
And your statement that you said was that if I, as their attorney, gave them advice to do what your hypothetical is suggesting, in this situation, the client asked me to handle, because of the lease, the violations of the lease and the threats that the fixing housing made before they filed this action, when we had to file the action in circuit court. Because of the threats, she wanted to have, my client wanted to have everything I's dotted, T's crossed, so that he would not be able to claim that she had not done what tenants are allowed to do, which is if the landlord does not make necessary repairs, which are the terms of the lease, the tenant is allowed to withhold rent, take on the repairs themselves to make the place safe for their boarders and their horses.
What's the operative word you're using in that whole statement?
Pardon me?
What's the operative word you're using in that whole statement?
The operative word is,
Assuming you're correct on the law, which is a little bit iffy, but that the tenant may.
she asked me to make sure that he wouldn't be able to proceed on his threats. And I agreed to just oversee the,
No, you did more than just oversee.
well,
That's the problem.
and Your Honor, what in this situation, we're here before you. We requested at our last hearing for you to set up an escrow account, a trust fund with the court to accept rent going forward.
So I understand that. I know what I did.
Mhm. That's what we're here to move forward with. Are you not going to allow me to represent my clients going forward?
Ma'am, I've not had a motion to force an attorney's withdrawal in this case. If I make that decision, then I certainly can make that decision on my own motion, but I don't have enough before me that I would feel comfortable making that decision. It is a monumental decision if a court directs that to happen. I will say, Ms. Tope, I'm concerned as to whether or not that's where we end up.
That will, excuse me, I didn't hear.
I'm concerned that that's where we may end up.
I share that concern. I would like to know how you would like us.
Well, I'm okay. So here's what I'm going to do, folks. And I really don't like delaying things. I like to try to keep things moving along. But Ms. Tope, because of the things that I've said, and I think you need to take what I'm indicating to you very seriously. Because there's no reason for me to. I really don't have a dog in that fight. There's no reason for me to say it other than the fact that you're facing jeopardy on a number of different levels. And so I'm going to do this. And I realize that it delays plaintiff, but I think the court is compelled to do this. I'm going to adjourn 1 week to the 21st at 3 p.m. And the basis upon which I'm adjourning is I think, Ms. Tope, you need to get the advice of counsel
Got it.
as to how you should move forward and if you should move forward.
Got that.
I also think, although I'm not ordering the defendants to do it, because I can't do that. I might suggest to you that if you've listened to what I've said today, if you believe in your interest to seek the advice of other counsel as to how you should proceed, I'm also giving that week for you that opportunity, should you so choose to do so, for you to do that. I'm not advocating for or against that. I'm just saying I'm giving you the opportunity so that you can make that decision based upon what the court has said. Okay? Anything else?
As I said at our hearing on last Friday, I'm scheduled to leave town for Thanksgiving vacation on the 20th.
Ms. Tope, I know, but I
Okay,
don't know what
can I appear by Zoom?
you can submit the paperwork. I don't know if I'm going to allow it or not. I'm not answering that right now. I mean, because I don't know on what, quite frankly, from week to week with this case, I'm not sure on which capacity you're going to be appearing. So you can submit the paperwork and then do that. I'll leave it there. I mean, I have a lot of concerns here, folks. I just do. Anything else from the plaintiff?
Your Honor, just so it's on the record, the court doesn't need to untangle the mess with Ms. Tope's accounting. But as the court correctly stated last Friday, the lease language is non-conditional. Tenants are required to pay base rent of $5,500 per month without any deduction or set off whatsoever. There's no factual dispute that tenants have withheld rent. They admit it. And longstanding Michigan case law in the commercial context, tenants' duty to pay rent is independent of landlord's alleged covenants to repair.
Okay. So what do you want me to do with that?
Say, to avoid untangling that mess.
Well,
it's clear.
No, but here's the thing. And there are certain, and I get what you're indicating, but I'm in a different boat. Understanding what you're saying is if a tenant recognizing their covenant to pay simply withheld the rent to try to get the landlord to do something. That's a different posture. Maybe they can do that. Maybe there might be a breach of contract in that regard, whatever. in theory, that wouldn't be allowed either, right? But we have another problem here because not only was that part done, but as I'm to understand, then those funds were then dispersed elsewhere. That creates a whole different ballgame. It creates a whole different ballgame, particularly where you're claiming a breach as to who did it, right?
Yes.
And
Yes, Your Honor.
that, so while I recognize and understand what you're saying,
Your Honor, I would.
it's all a mess, and they're sort of a mess on both sides. Less of a mess over here, more of a mess over here. I gotta try to clear that mess before I can even begin to deal with that. I've always wanted to use mess as a legal term. Go ahead.
It may be a term of art. I would just say it's the mess that's being caused by tenants, and they're responsible for the actions of their agent, is causing my client prejudice where he's not getting paid any rent, and tenants are operating their business on my client's property rent free. So my client is the one who's being prejudiced by the mess.
And counsel, I'm well aware of that, which is why I'm trying to at least make some decisions, understanding the other action that was going on, but make the decisions within the confines of this month, which is why I'm not moving beyond. I realize that there is prejudice to your client, at least in terms of the funds being there. As I'm sure you understand, the other issues over here, I've got to deal with, because I think unless they're cleared up, it's going to be even more prejudice to your client, because you're going to be Don Quixote in terms of who you're trying to argue against.
Understood.
And that has to be solved. That's also why, despite Miss Tope's travel plans, I'm not going to my next date of December 5th.
Okay.
Because I don't know that come the 21st will resolve anything. But I got to give that opportunity over here. I have to allow that to occur, I think, in fairness, and just to make sure that the proceedings are what they are.
Understood, Your Honor.
Can we address the order that you gave to set up an escrow account and how much should be put in it? Because the plaintiff in this case was paid $3,600 and some dollars for the rent on November 1st. Are they to put that into the court-ordered escrow account?
What I ordered at the last hearing on the 7th,
Mhm.
the monthly rent is $5,500,
Yes.
correct?
Correct.
What I ordered was that $4,125 was to be placed in escrow by the,
By today,
yes.
right? Is that?
And then $5,500 going forward. Pardon?
Is that the November 1st rent payment or?
I prorated November.
Okay,
That's how I get 4125.
okay. So the check that they got for 3,000 some hundred needs to be put into escrow.
So where's the 3,000 come from?
November rent, and the only amount that was withheld for necessary repairs was taken out of that. That is, my accounting is, I tell you, it's not a mess. The accounting is very clear, and the exhibits for every invoice that was paid is very clear.
Okay. So the last time we were here, and I can't recall independently what the amount of the check was. Did you receive that check?
Your Honor, yes, we received it yesterday. And we sent a reservation of rights letter to,
Okay, so that was for how much?
3508.96.
Oh, for Pete's sakes.
It was sent on November 1st before you made your order to prorate. So we are prepared to make the difference.
And the deduction from that are
Yes.
what?
It was the temporary repair of the leaking spigot out in the pastures before frozen ground. And we asked them to please repair it, and we got no response. And
Hold it,
you know,
hold-
the ground
hold
froze
it.
last week.
Well, it didn't really freeze last week.
Well, it would have frozen in the
Michigan,
spigot out in the.
that was not a freeze.
It was 27 degrees for 2 days.
I know what the temperature was. I'm just telling you, it was not a freeze of the ground.
There was frozen ice in the bucket.
Oh, for Pete's sakes! All right, fine. It's frozen ground. I don't care. That was not a. We had frost.
For a spigot out in a pasture to give water to 1,200-pound horses, 35 of which are on the property, we needed to have a fixed spigot that wouldn't freeze. And that's what was withheld from the $5,500 rent due 11/1.
Let me ask you this: did you cash the check?
I told my client not to cash the check because I knew about this hearing and we had to send our reservation of rights letter. So we still have it. It would seem like triple, prejudice if he now has to give it back. And I don't understand really why opposing counsel decided to release this amount. I don't know, Your Honor.
Either.
It's in the accounting that
And
was
it-
filed.
It came right before our motion to compel payment of rent hearing.
Here's what
I will leave that there.
I'm gonna. You know what, Ms. Tope, I don't believe that on the face of it, your clients had the right to withhold any portion of that base rent. On the face of it. Now, it may turn out once everything's litigated, something else comes out in the wash, but on the face of it, they're not entitled to do it.
They asked him to repair the middle of October.
Okay.
Got no
You keep
response.
saying that to me. I don't know why people don't think I hear. I hear everything. You saying it to me over and over again doesn't make it more true. I hear you. I can hear all kinds of people. I do it every day. That doesn't mean that I agree with you. So since, as I see from this, just the lease language itself, that they would not have been entitled to do that. Plaintiff may do what they wish with what they got. I am not changing my order of November 7th so that the 4125 must be placed into escrow. with the court, and then 55 each month. If it turns out, so that your clients understand in the end, that what you were doing was all, then seeing the accounting, and I'll do the math, and we'll figure out what needs to be paid or what gets credit. We'll figure that out in the end. But at this point, 4125 is expected to be an escrow.
Paid by my clients. What about the check that they received? Is that to be returned? Not,
No, I'm not going to order them to return it.
they can cash that check.
Yes, because here's the problem, Ms. Tope. You're making your own like accounting and math up on the ledger. Because you're saying, well, we sent this for November, and so therefore they need to send that back to us before we pay the prorated amount of November rent. Well, that would go against every accounting principle in the world because he applies it to the oldest debt, which is the month he didn't get paid, which is not the first month he didn't get paid, which is not November. So if he applied that to that, November hasn't been paid. So whether anybody likes it or not, we're going to use my accounting, my math. That's what we're going to do. So I'll make it real clear for everybody. They keep the check. You've got to pay 4125 into escrow and then 55 beginning December 1st. Any other questions from anybody?
Nope.
Your Honor.
Fantastic.
Thank
We'll
you.
see you next week, 3 p.m. Pleasant Lake Park versus Christopher Genowek.
Good afternoon, Judge David Morris on behalf of Pleasant Lake Park LLC.
Your name, sir?
Christopher Genowek.
Genowek. Okay.
Don't use a V.
Got it. All right.
I apologize when I exited last encounter. I just a little bit of pain. My first time in court. I wasn't just wanting to get out of the Thunderdome. So, Mr. Allen, good to see you again, Mr. Allen.
This is the Thunderdome?
I consider
We're
when I'm sweating it's a Thunderdome.
Oh, okay, okay. 'Cause
98% of places I encounter.
I was gonna we could put something outside the Thunderdome. All right. Okay, where are we on this case?
This is our third hearing on this case. Last hearing, the second hearing, court directed plaintiff to engage a critter control business to do an inspection of the
Correct.
and directed that the defendant put November rent into escrow. Because of the timing, I drafted and have a signed unsworn declaration of the inspector that can produce to the court.
Okay. Yes. Have you seen it, sir?
I haven't seen it. I mean, I know,
Okay.
I know what it may say, but
Well, go ahead and look at it.
I'd rather hear your evaluation. But I'll read it. But this is quite a lot. I don't want to waste the court's time.
Well, not, right?
It's a lot of points.
I'm getting paid, so you're not wasting my time.
I may need to adjourn to call my attorney if that's free and that's been referred to me for free by the state of Michigan. I may need to refer this. I may need to adjourn. This is a lot. But I have prepared my statement.
Well, right.
Which is brief and short.
Well, but hold on a second, sir. So I'm looking at this, and there were certain specific things that you complained about that were happening as a result of an infestation of some type. This is basically indicating that there is not or no evidence of an infestation.
So
That's completely contradictory to the reality in which we live in. So I was interested to see I wanted to see what Mr. Weasel's inspector said, and to make this very clear, I think this is the most important part. Mr. Weasel inspector is my next door neighbor. He never provided a valid card. His company is not licensed or insured, and he hasn't proven that. He's my next door neighbor, and I believe there's a conflict of interest. Mr. Weasel owns a trailer park that the inspector lives in. There's a major conflict of interest. This is the burglar investigating himself. And I'm satisfied with whatever you decide, of course, but there's rat poop in my living room, and Mr. Weasel.
Okay, hold on, sir.
Okay, there's a lot of.
So why, I guess part of it, my question is, why didn't you put the money into escrow?
I just forgot. I'm looking for a job because I'm unemployed. I have the money. I can prove to you with bank statements that the money's there. I have over $3,000, almost $4,000 maybe, but the money is secure. It's there. I'll have.
Well, but hang on. It's got to be placed in court escrow.
Okay.
Right.
It's
And
my first rodeo.
but I was kind of clear with you that you had to place that within 7 days of the last hearing, so it should have been in at the beginning of November. No, by November 7th.
That could be an escrow within by the end of the day. I was really just focusing on employment because I haven't been sleeping because there's a lot of rats and mouse. I spoke to Mr. Weasel this morning, and we both confirmed that we're going to do more inspections and maintenance. And that he confirmed to me that the baseboards in my kitchen are like flappy. And we didn't look for that because there's many holes around the skirting of the trailer. So that has been about almost completed, the skirting around my trailers.
Are you planning on hiring an expert to get this tested?
I wasn't prepared for this denial of reality. So now I'm forced to call like Terminex. That's like a licensed and insured inspector, not a licensed. The gentleman that did this inspection.
I hear you.
Okay. The gentleman that did this inspection, literally lives 2 houses down, and he doesn't own a car. His car used to say Critter Control on it, but it's gone. When I asked him where his car was, he said it's in the shop. The gentleman is very kind. We were all three at Mr. Weasley.
Oh, okay. All right.
We all witnessed poop in the house, and the poop is still there. There's still poop in my house. There's still holes in my kitchen and multiple places. The evidence is coming out of my ears. But I was not prepared for this denial of reality. I was expecting a deal, so we could all go back to living in peace and harmony. I was not expecting this to go on.
Well, have you called?
I'll call Terminex now.
No, hold on. Have you called? If you were expecting a deal, have you called the attorney's office to see about working something out?
I spoke to Mr. Weasel about making a deal multiple times in person and on the phone, and he just says he doesn't want to talk about it. But that was a few days ago. But when I talked to him this morning and complained about continuous rat poop and that the baseboards are now there is super evidence. There is chewing, and they're chewing on the rug in my second bedroom, and the carpeting. There's like carpeting all over my house.
Sir.
Yes,
I heard you the first time that you were here. I'm hearing you now. I understand that what you are saying is going on. That is why I asked plaintiff to get somebody in there to look at it, to provide something to the court with regard to what basically do an inspection to see if there's anything there.
Yes, Judge, there was an inspection done by Stephen Stamper, and frankly, to the point, to the allegation that there's some conflict of interest, I'm personally not aware of his living where he lives, but this statement submitted under the penalty of perjury by a person who is qualified to do animal control, frankly, our court system would come to a halt if we just said that someone knows someone who did something and they made a sworn statement that this is a legitimate sworn statement. He will testify to the truth of these matters in an inspection of the outside and inside of the premises. there was no signs that and I spoke to him regarding this, he found no signs of ongoing animal activity. Really the primary purpose for this inspection was to look for something like a beaver or a bear under the premises. That he found one several-month-old animal dropping that he believes to be from a cat. He had done prior trapping events and really nothing, there is no ongoing animal activity under the premises. He found the condition inside the premises, which we believe to be, or he believes to be, a product of the tenant's living condition, is conducive to mice and rodent presence. He didn't find any specific evidence of current mice or small rodents, but he wouldn't be surprised if there are mice or small rodents that would be attracted. And it's the landlord's position that that attractive nuisance can be mitigated by the defendant, and any further work or trapping needs to be done in conjunction with cleaning the interior of the premises. So frankly, it's a large number of properties have mice and other rodents, and it's not surprising that he may see signs of a mice.
Michigan in the winter and there are mice indoors. What a concept.
So point number 17 is clearly perjury. I did not see any signs of ongoing animal activity inside the premises, period. That is completely false. And all three of us were there, and we witnessed poop in my northeast corner. And there's also poop underneath my stove, and we need to reevaluate the baseboards, and that will wash away.
All right, sir.
This delusion here.
Sir, how long is it going to take you to get Terminex out there, or whoever you're going to get out there to give your own?
So they said they would do on the website. It's like the next day for a free inspection, and then so I guess there's a free inspection the next day. But if there's going to be any kind of action, that's going to cost a whole lot of money. There's rents, and the things are in the vents. The baseboards right now, ground zero is the baseboards. That's all I'm complaining about. But specifically, number 17 is he's liable for perjury in that, and I may pursue him to go to prison.
You have at it. Okay.
Specifically 17.
Okay.
That's all. That's my first thing I look at.
You have at it.
Can I make one comment here? Thank you. That Mr. Stamper took what he called an endoscope, which I believe to be a camera attached to a small tube, and went in the heater vent because that was complained of. There was no findings in the heater vent.
I never complained about the heater vent.
There was also a purported hole in a cabinet under a kitchen sink that was inspected. So this moving target
I hear you, counsel. Because the last time we were here, we weren't really even dealing with, at least I didn't think, small rodents. We were talking about large
I made a point on that.
animals.
I made a point specifically because I knew you were going to comment on that. So we have done the deduction process. The skirting is complete. Almost, I think, complete. Outside my house, there's 2 mouse boxes, and then he also bought me vent covers because there was holes in the vents. That's been completed. So we covered, and then after we got the deduction process, and now I'm like, where is all the chewing and noising?
Okay.
It's the baseboards. The baseboards is ground zero. That's
all right. We're all in the baseboards.
Baseboards.
But that's what you're saying.
Baseboards. Sorry. I'm just sorry, Judge.
So, plaintiff got their inspection. I am looking at that. That does not show any signs of anything that you complained of the first time. You are going to, although it seems it's a different thing now, irrespective of that, you are now going to get your own inspection. So my question is, how long is that going to take you to do? Because at some point, I'm getting this thing. We're going to try this thing.
Right.
I'm not going to listen to it every week without.
Yes, Judge.
Render a decision.
Yes.
Go ahead.
Yes, Judge, I'm gonna go on the internet and I'm gonna contact Terminex. I'm gonna do a free inspection, like as soon as I get home. And I mean, they may arrive today or tomorrow. I mean, probably tomorrow.
All right, great. If they arrive tomorrow, then I can put this off 1 week.
Yeah.
Got plaintiff's inspection, which doesn't show anything indicating what you were saying before, but now admittedly, as plaintiff has said, that the target has changed, but now you get your inspection and then we'll see
I'm
exactly
still-
where we are.
The skirting, I'm not satisfied.
Okay,
Yeah, I mean,
and that's, okay.
I don't want to be here forever, but I mean, my trailer is the closest to the wood line and there's a lake. This is all.
I know you told me, closest to a wood line, there's a lake. That's where I think the big beaver like thing came from before. Yeah, I know. I heard you. You know, people don't think I'm listening. I hear everything. Even though I don't want to sometimes. I hear everything. So I'm going to adjourn this to November 21st, 2025. What time? 3 p.m. And the defendant, you're to do two things. I want that escrow paid. And you're to bring your inspection report.
Yes, Judge. Thank you, Judge. Thank you for your time.
All right. Thank you.
Thank you for your service.
You're welcome.
Judge.
Thank you, Counsel. It was much better than last time. It was okay.
There you go. Good
Okay,
job.
court calls the cases of the people of Town Center Place versus Singred Melville.
Jackie Snyder Powder for the plaintiff, Your Honor.
Her baby.
Yes. I know. Hello, Mr. Melvin.
Thank you.
All right, state your name.
State your name.
Oh, Singred.
Which she needs to.
Yeah, I know.
Oh, there are.
Thank you.
Oh,
Okay, can you hear me?
yeah.
Okay. And so where are we on this? I have updated photos.
Yes, Your Honor.
Can I see the photos?
I
Can you
sent
see
them
them?
by
Yeah.
email to you, Miss Melvin,
Did you get your email of them?
yesterday afternoon.
At the moment.
Okay. She could see my copies of them. Yeah. So while she's looking at those, are there any other issues with it, with plaintiff? Did the sink get done?
The sink did
Yes.
get done, Your Honor.
Yay.
I believe I got an email today that they need to go in and check Monday for the furnace and HVAC system. There's a furnace and HVAC issue apparently.
Okay, so they're gonna check the furnace on Monday.
Yep.
Oh, what does that mean?
That means there's an issue with your furnace,
Oh,
so they're gonna come in and check it over. Make sure it's operational and everything's working for you.
well,
Okay?
okay.
Was there anything else?
Not that I was aware of at the moment.
And I
Besides
think
the
we had,
plethora
they
of
got
things.
the balconies good now?
Let me look at the picture.
We
It looks
had 6 days of a wild work of eliminating stuff out of my apartment, out of the balcony. We've been working very hard and and yesterday, was it yesterday or the day before, the guy came for the sink
and everything out of the kitchen got back put into the living room on that. And then she had the nerve to come and take pictures.
It's okay, Miss Melvin.
I know.
It's okay, because here's what they said. They said the sink got done, which is what we wanted. I don't think there's any additional or problems now with the balcony.
Well,
There's
Or is
nothing
it?
left on the balcony.
Hold on.
Everything is gone.
Miss, okay. All right, Miss Melvin, I got you.
Yeah. Okay. My son will.
Okay. Okay. It's all right. And I think, were those the only issues we still had left?
I besides the plethora of other issues regarding the mice, etc., for her to get done, as far as I'm aware, I'm not sure that the inside is up to code, but
I think her son is here also, and
okay.
he has been moving things out of the way, but have they come back for an additional inspection on that, sir? Do you know?
I'm just gonna play here to help in this.
Okay.
I'm having a hard time hearing
The
that.
back side of the table. Okay, as you know, they had to come and redo the kitchen countertops.
Right.
Last week, I had everything nice, everything was looking great. I had to move the stuff out of the kitchen. No only place to put it was, these items.
So the stuff in the picture is stuff you had to move out of the kitchen.
Coffee pots and stuff on top of the counter.
Got it.
And we put them in the boxes, boxes. Probably got a pile like this. And there's either put them in the hallway outside or on the balcony and in the one space. So that stuff isn't there. The only reason it's there is because
You were required to do that for the kitchen sink.
Okay.
Got it.
So
Okay.
the issues with the balcony and the other thing, it sounds like they need to come back and re-inspect.
Yes.
Okay.
So
I think, correct me if I'm wrong, I think that she was supposed to keep stuff off the counters for 24 hours after they did it. And if they just did it yesterday, probably midweek, they would come back. Is that your guys' understanding as well?
They did the kitchen yesterday?
kitchen yesterday.
Okay.
So it needs
for 24 hours.
Okay.
24 hours.
Yep.
Or till Sunday. The balcony, Renee was there. She stuck her head out there, took pictures. She said it looked fine. I don't know if you saw the pictures from last time.
Yes.
Yeah. Basically, the stuff here, there's 3 flower pots. There's a table in the corner. The gray partition here, the lattice. The neighbor has a dog. She walk outside area. The dog runs up and down her balcony.
Got it. Okay.
Other than that, it's just a table.
Okay. So
back in the kitchen, so.
Right.
Once they get it back in, do the inspection, I'm gonna let them give me a list of what they think needs to be moved. It looks good.
When they left, he's like, well, I understand this stuff. You know, being here because we had to take it out of the kitchen.
Got it.
You know,
yeah.
She had a rack that was on the wall, and she's got all her spices and teas, and we had to move that, so.
Oh.
I was under the impression that we were all set, you know, put the stuff back.
Well, let's do this. Let's get an inspection, get their final whatever of what they need done.
Yeah, the HVAC went down, it was last week. She heard a loud pop and she went to turn it on. And, you know, it was after hours. She had the fire department. Well, you know, and the fire department said, no problem.
But they're gonna have it.
Qualifications for, but turning on the air conditioning or the heater wasn't working. And when I was out the other day, the maintenance guy did come up and I thought they checked her name. There
first, and the maintenance guy, well, turned it in, it's like, this is definitely not working.
Got it. Okay, so somebody's gonna check that out.
Yeah, and that corner,
Okay.
he's like, I need this corner cleared out. So, you know, small touch, had to take that, move that back over to the apartment.
Okay. All right, real good. Here's what I'm gonna do. Let the inspection, let the HVAC thing take place, do an inspection of the unit, get the final list of whatever problems they may have, not have, and I'll adjourn this out to December 5th,
Okay. Do you want to
2020 at
there in person, Your
3
Honor?
p.m. Pardon?
Do you want us there in person, Your Honor, or can we appear by Zoom?
You may appear via Zoom.
And what time, Your Honor?
3 p.m.
Is there any way we can do it earlier? Because
I get on.
Can we? What time do you get out?
2.
You get out at 2. I can't do it earlier. And that's the time you guys would be set.
yes, sir.
Send Wasbury.
I'm going to have to because otherwise I have the kids and
No, I know. I
yeah.
do what I can.
If we can do by Zoom, I might be able to make it, but it's hard with them and getting them off the bus. And
I hear you. Okay.
our house
Thank you,
gets
folks.
hectic after 4:30.
No, I understand. All right. Yes, Miss.
The way those pictures look is not the way I live.
I know.
Everything is over here, this is over here. It's gonna take me 6 months to get back to normal.
All right. Miss Melvin?
My blood pressure is over $200.
Oh, yeah, I got you. Go. Okay.
Express the way there is and the colors and there's outlets, we get to put it all there.
Okay.
Great.
Miss Melvin, you're okay. Okay. I get what you're telling me. I understand why the stuff's there. Okay. So we will see you on December 5th. Miss Melvin, you have a wonderful Thanksgiving. Okay. Take care.
Thank you, Your Honor. Take care.
Thank you. I don't have the other side here, but Mr. Meeks, could you come on up?
Thank
you, Your Honor.
Since she did all the moving and that, can he get compensated for it?
I don't have a fund to compensate him.
No, but he even took off from work.
You're not gonna get compensated for me cleaning up your stuff.
Thank you.
Thank you. God bless
Thank
you.
you.
Oh, God.